Good morning, everyone.
Good morning.
Let me thank you for joining us here today for what I consider to be benchmark legislation, the Congressional Disclosures Protection Act of 2008. I'm really pleased to be here on the day after the celebration of Martin Luther King's birthday, because in some ways this is the second civil rights law of this century, the first being No Fear 1. And it is our intention to put teeth into No Fear 1. It was a good start that addressed the reality that we had significant problems in the federal workforce in terms of discrimination, as well as significant problems in the federal workforce in terms of retaliation, both retaliation for claims of discrimination, but also retaliation for whistleblowing. And why is this important? On the one hand, discrimination is totally unacceptable in our society. And if it's unacceptable in our society, it has to be unacceptable within our government. But yet a lot of people are significantly harmed by discrimination in the federal workplace. And so we are trying to put teeth into a law that will enable people to file claims of discrimination in the federal workplace and not have to suffer retaliation. In the second instance, we're concerned about whistleblowing because whistleblowing is a mechanism by which the folks who are on the inside, federal employees within the agencies who actually know what's going on, are in a position to let members of Congress and the public know when their government is failing them. Now, we all know government often fails, but it is only through the work of whistleblowers that it comes to our attention. This is a massive government. And I am under no illusion members of Congress or the U.S. Senate or even the administration know all the things that are going on. Because sometimes there are individual decisions by an agency head, by a supervisor, that can result in fraud, that can result in waste, that can result in an abuse of the governmental system, and it can result in significant losses to the taxpayer. So we're also concerned that when these employees step forward to bring these internal problems to our attention, that they are not victimized by retaliation. And I have to tell you folks, retaliation is serious.
Yes.
Retaliation destroys lives, destroys families, because when you don't receive the promotion you're entitled to, when you're transferred out into a dead-end, no future job, that has economic consequences, that has psychological consequences, that also has health consequences. I've seen people with raging high blood pressure directly linked to the mistreatment they've received as a result of filing a claim, a whistleblower case. I've seen people literally crying in my office over the treatment that they received after filing a discrimination case or after saying that a supervisor or an agency has done something inappropriate. So we're going to have to address this issue, and I'm very pleased to work with Reverend Fontroy and Ms. Marsha Coleman-Adebayo, who's been a leader on this issue, and other federal workers to bring this issue to the forefront and to craft a piece of legislation that we think will address these dual problems. I'm also very pleased that this bill is supported by one of the co-sponsors, Ms. Sheila Jackson Lee of Texas, who's been a strong fighter for civil rights and fairness in this Congress. Let me take a moment, because I don't want to prolong this, and talk about what this bill accomplishes. We've made several important changes in our existing laws that will give whistleblowers the tools they need to defend themselves against retaliation and discrimination. First, under current law, whistleblowers who are the victim of retaliation and discrimination are required to submit their claims for administrative review, many times resulting in long, drawn-out, and costly reviews that only result in unnecessary delays in resolving the dispute. In fact, many whistleblowers have found that this lengthy and costly process has been a means to defeat claims or discourage claimants from even making a claim. And I've heard this on many, many occasions. First, this bill provides a mechanism for these whistleblowers to seek immediate review in federal court. Immediate review in federal court. And this is something that whistleblowers have sought and desired for a great deal of time, for a very long time. The administrative review process has not worked to help the whistleblower. It's actually worked to help the person, the agency that has committed the offense, and work to the disadvantage of the whistleblower. Second, in an effort to create a stronger disincentive for rogue, I think that's an appropriate word, rogue government actors to retaliate against federal whistleblowers or agency heads to acquiesce or cover up that conduct, my bill provides triple damages that can be rewarded to victims of retaliation and discrimination. And this is very important because part of what we're attempting to do here is create disincentives that are systemic that will discourage the kind of conduct that I've described this morning. So we believe the treble damages will accomplish that goal by saying to the agency or the offending actor that you are going to pay if you engage in this misconduct. Any victim of retaliation will tell you the damage suffered to their lives and profession cannot be quantified simply by looking at the wages lost during the period of retaliation, which is why treble damage is so appropriate. Third, many whistleblowers have informed me that the most difficult obstacle to overcome in defending themselves against retaliation and discrimination is finding a good attorney to represent them. How many times have I heard this story? Congressman, I've got a good case. Congressman, they've retaliated against me, they've denied me promotions, they've sent me to a dead-end job, but I can't get an attorney to do anything. And unfortunately, as a member of Congress, whereas I can call the agency and I can attempt to job on the situation, I don't have the clout that the attorney has when it comes to the court of law. Many potentially meritorious cases never get off the ground because the whistleblower does not have the money to pay for a good lawyer. The bill does two things. First, triples the attorney's fees that can be awarded to lawyers who receive favorable decisions in court. I'm a lawyer, I know. That's an incentive. It will create a financial incentive for our best lawyers to take these cases. And I think our federal employees are entitled to the support of our best lawyers. Second, and I think this is very important, it gives a whistleblower something they've never had before. The ability to request the Office of Special Counsel to represent them in the prosecution of their case. Finally, the bill provides more transparency and accountability in the federal government by requiring agents to disclose the amount of money they spend defending these claims. There's the spotlight. When the agency spending money defending cases against whistleblowers instead of spending that money on mission-related purposes, I think that will get the necessary attention and also provide the necessary disincentive. By shedding light on the amount of money the agencies are spending in defending these claims, the public will have more knowledge about the spending patterns of each particular agency as it relates to whistleblower cases. I'm very pleased to be a part of this effort. We've had a lot of people contribute, a lot of hard work, a lot of patience, a lot of review. I want to recognize Ed Hubbard, who just came in, who's my legal counsel, who's done a lot of networking. One of the champions is going to speak next, someone who I'm a great fan of, a great admirer of, and that is the Honorable former Congressman Reverend Walter Fauntroy. Reverend Fauntroy.
Thank you, Congressman Al Wynn, arousing. Congressman Chris Van Hollen has come in. Chris is one of those who carries the torch for justice and peace, as did Martin Luther King Jr. in his own day. Thank you, Chris. It was my privilege in the tragic yet triumphant decade of the 1960s to serve as Martin Luther King Jr.'s personal representative to the President of the United States, to the leadership of the U.S. House and Senate, and to the cabinet level agency heads that had relevance to our struggle in this South, particularly Attorney General Robert F. Kennedy, then Attorney General of the United States. And after Dr. King's tragic assassination, some 40 years ago now, I became the first member of his staff to become a member of this body, this most powerful body in the world, on which only about 10,000 people over the course of our history have been able to serve. I'm glad you were one of the 10,000.